Hello and welcome to the Study Legal English podcast. I'm Louise and today I've got a very special guest with me. It's Alex Woods. He's a litigator with over 20 years of experience. He runs his own firm called Redwood Legal. So hi Alex.
Good evening.
Good evening.
Good evening.
You specialise in cohabitation disputes and disputed wills, contested wills. Yep. A lot of that small individuals and small businesses. So do you want to talk a little bit about why you decided to get into litigation?
Yeah, I think partly because crime doesn't pay.
Yeah.
Ha ha ha. And that was what I was in like 10 years ago now.
Yeah.
And that is actually my background as a criminal litigator from when I was a young lawyer. Mm-hmm. And I realised that it wasn't really a sector to be in the long term. And I stumbled on financial mis-selling litigation. Mm-hmm. Mm-hmm. Being the crusader who actually ended up on a silly daytime TV show, helping people who had issues with the banks, the PPI, payment protection insurance stuff, the interest rate swap stuff. Mm-hmm. Anyone who'd been diddled by a big high street bank, I was prepared to jump on my charger and go after them. Yeah.
Why did you feel so strongly about representing these people?
You know, we're products of our childhood, aren't we?
Uh-huh.
As we were talking earlier.
Yeah.
And I worked for my father's business. He was quite a successful, he was director of a manufacturing company in Colchester in Essex. Mm-hmm. So, sort of a self-made man. And for a couple of years, I, flirted with the idea of the son following the father, working in the family business.
Yes.
And in the legal department, we came across a big construction dispute. My father's company had done a lot of work for Balfour Beatty.
Mm-hmm. Yeah.
And you may or may not wish to edit that name out of the video. And we were in his boardroom. And the legal team from Balfour Beatty were there. They weren't paying about £170,000 worth of invoices for noise proofing of a big construction job that we'd supplied for them. And they were pretty much, all right, sue us if you like.
Yeah.
We have bigger lawyers than you. You are a small business. You won't be able to go the distance. You won't be able to afford the risk of losing and ending up saddled with a six-figure legal bill.
Gosh.
That fear alone made the company settle on very unattractive terms.
Yes, yeah. So you kind of felt that kind of gave you this, I don't know, it encouraged you, it motivated you to want to represent the underdog, maybe.
Well, yes, it did indeed. And I guess the crusading spirit hasn't been entirely knocked out of me, but it also identified a problem. And that problem is you've got a very strong claim, but you're not well heeled enough to take it through the court system. So I've, over time, first with the financial mis-selling litigation, which I did on most of the cases I did on a no-win, no-fee basis, I developed a business model where I took calculated risks with cases that I thought were strong in return for a percentage of the winnings, of the client's winnings. And that allows access to justice for people who might not otherwise be able to get it.
Yes. And you mentioned that you mentioned very briefly that you were on television. Was that Rip-Off Britain?
Yeah.
Yes, very good.
Gloria Hunniford and a couple of other luminaries from the television industry. I forget their names now.
Yes, yeah. And in fact, it was via video that I came across you, because as I was researching small claims for the podcast, I found your excellent YouTube channel, which has got lots and lots of resources and really, really helpful. So I'm going to leave a link for listeners and for people who are watching the video to check out that YouTube channel, because it's very, very helpful. So you mentioned that you deal a lot with no win, no fee. Can you explain a bit about what that actually is?
Watch one of my YouTube videos. I did a YouTube video recently, which I really did try to give the skinny and just give it in a nutshell. Because unfortunately, unlike in America, where you can just say to a client, look, give me 30% of what you win and I'll work for free. It ain't quite that simple, because, you know,
there were some reforms a few years ago.
There were some reforms, and we'll definitely remind me to mention that. But the big background goes back to the Access to Justice Act, in which Parliament said, look, we've got to give access, not to poor people, to people on middle incomes who can't get legal aid. And no win, no fee was created out of that parliamentary initiative. Basically, all the client needs to know is you're going to have to part with a percentage of your winnings. Let's put some flesh on the bones and take a contested will case. You know there's a big estate, someone's died, they've left $1 million in property, whatever it might be. You go to the lawyer and you say, look, I think I've got a claim against the estate for whatever reason. And the lawyer says, okay, here's my hourly rate. And you go, and then you say, is there another way? And you say, well, yes, I could, if you like, leverage that future pot of gold that you might get and take a cut of it in return for working for free. And that cut depends on all sorts of factors. But let's say it's 25 or 30% typically. But why it's not a purely kind of contingency is the clever word, legal word. Why it's not purely just a share of the pie is that there are expenses that you would probably have to cash flow: court fees, experts' fees, perhaps barristers' fees, and critically, and this was part of the design of the Access to Justice Act, because the parliamentarians or the judges acknowledged and recognised that it was all very well me working for a share of the pot of gold, but what if, and this comes back to the construction case I was talking about that my father's manufacturing company experienced, what if you have to tell the client, if you lose, you don't have to pay my fees, but you have to pay your opponent's fees. And if they get an expensive law firm, that could be huge. So the Access to Justice Act built in a protection whereby you could take out this special insurance, and that insurance would pay for your opponent's legal bill if you lost. Does that make sense?
Yeah. And
so that was an expense. Insurance premium as well as court fees, experts' fees, barristers' fees. So although you are, you know, your lawyer is working for free, and that's probably going to be 60, 70, 8% of the fees in the case. There are these additional expenses that someone has to cash flow. And if you want a law firm to help with those fees, they're going to take an even bigger share of the pie.
And weren't there were some reforms about 10 years ago that were trying to, like you said, to limit some lawyers asking for too much money or asking for a lot. Was that some? Yeah,
well, you know, it's a seesaw, isn't it? The law. So what then happened after the Access to Justice Act? The personal injury lawyers' eyes lit up because they could see that there were golden times ahead. Because if you do win, your opponent has to pay all of those expenses, all of your legal fees, and this is why it's not purely a share of the pie arrangement. your uplift, because it's not actually, although as far as the member of the public is concerned, it does look like a slice of the pie arrangement. It's not. The deal is the lawyer, if he wins, is allowed to increase his hourly rate up to 100%.
Wow.
So you're then, technically, your legal bill is double what you thought it was.
Yeah.
But if you win, the other side pays that. So basically, the insurance industry, motor insurance especially, because it's the personal injury solicitors out there who've
those accidents.
Yeah. So the insurance industry didn't like it because their lawyers were having to shell out, and obviously, therefore, the insurance industry, will have to shell out very large legal cost orders against them, as well as the actual personal injury damages themselves. And they went crying to Parliament, and in 2013 they cried so hard, and the parliamentarians decided that we lived in a compensation culture, and now we've seesawed the other way.
Yeah, so it's some more stricter rules came in.
Yeah, and basically they dismantled what I've just described.
Yeah.
Not entirely, but substantially.
Yeah.
And a lot of personal injury law firms have now gone to the wall, or are going to the wall.
Yeah.
It's still possible to do it, but you have to look at it at a case-by-case basis, and also certain sectors where it works, and certain other sectors, areas of law where it doesn't.
And so talking about litigation, what, just as a brief overview, what do you think, what are the key skills you need to be a litigator?
I think you need to you need to have a very thick skin. Because day in, day out, you are writing nasty letters, you are getting and reading nasty letters.
Yeah.
And you're making nasty phone calls, and you're getting nasty phone calls. And unlike a fancy barrister with his wig and his gown, he picks up his brief, and he swans into court, and he's like the actor, the performer. After the show is over, he goes home. But the litigator is there for the not just the battle, but the war. And that requires quite a lot of determination and tenacity. You don't really want to invite a litigator to a dinner party, because they're quite aggressive, and they'll make you feel very stupid if given half the chance. Because
they like a good argument.
They're designed to be not just in court, for an hour during a hearing. My honour, I submit that. They're designed on the phone, dealing with the client, dealing with their opponents, dealing with their own staff in quite a ruthless and aggressive way. Yeah. Now, I'm sure there are very good litigators who are sweet as honey and lovely and, and big cuddly teddy bears. But the ones that I've met, the successful ones, they're not the sort of people that I would invite round for tea. Yeah,
need to be a bit hard to deal with all of that, I imagine.
I've seen friends dismantled over a drink. I had a good mate, businessman, and he came for dinner with the litigator, and just somewhere out of the blue, the litigator just decided to go after him. It's like having a Rottweiler. They belong in their cages or chasing wild animals or whatever it is Rottweilers do. Yeah. But you don't, introduce them to your children, do you?
Got to keep them at an arm's length. So can you give some examples of some interesting cases that you've worked on?
I can. What would you like? A Swedish cohabitation property dispute, or suing the Bank of America?
Ooh, suing the Bank of America, I think, especially at the moment with all of the trade wars going on, it's quite topical.
Well, I've made it sound grand now, but it was one of my favourite, although nail-biting experiences. I represented a lady who in Milton Keynes who was unhappy about. It was quite a small case. It was only sort of £10,000 value, and we were going after MBNA credit card, which is owned by the Bank of America. and we were suing them for them mis-selling an insurance product on her credit cards, and she had credit cards coming out of her ears. She had numerous ones with the same credit card company. But back in the day, unfortunately, credit card companies were on a gravy train, and they were sticking insurance products on credit cards without telling the customers.
Yes, yeah.
And the wonderful thing about credit cards, Einstein called credit cards and compound interest the eighth wonder of the world. Because over time, and everyone has a credit card, or did have, the curve on a credit card, on the interest and on the principal, goes like that.
Yeah, just completely
as
out
interest
of hand.
compounds.
Yeah.
You wonder why they were handing them out like confetti. That's the reason.
Yeah.
And
no one can pay that back. I mean, you know, well, very tough to, if you've got several credit cards.
Yeah, it's tough to get out of the credit card. What's the word? Downward spiral.
Yeah.
It's a problem. Anyway, we brought this claim against MBNA, and I actually I instructed a barrister in his first trial that in a very good set of chambers, not far from where we are in Lincoln's Inn, and it was a top commercial set, but they wanted their young barristers to cut their teeth by doing proper trials, because young barristers in commercial sets just are little juniors and do support work for big commercial cases. So this is something that excited this particular barrister. And he pulled out all the stops, and I mean, I thought it was very 50-50 whether we would win or not, but he managed to persuade the judge, who wasn't very familiar with this type of financial mis-selling litigation, and we beat them. But the bit I liked about most, and you might have to edit this out because it shows me as being a bit disreputable myself, is I actually took a £10,000 interest-free lump sum from MBNA credit cards to cash flow the litigation. And then when we won, they had to pay a very large cost order. It was like £35,000 on a £10,000 claim.
Yeah.
Because they were fighting it for the principal.
Yeah.
They didn't want other people to be encouraged by this result. So I then used the money they paid me in legal fees after we'd won to pay off the £10,000 loan that they'd given me on an MBNA credit card.
Wow.
It was, sadly, it was very satisfying to me that I had cash flowed the litigation in that way.
Yeah.
Because the big problem with running no win, no fee litigation for a law firm is you're not being paid for 18 months.
Yeah. Yeah, it's tough. I mean, how do you do it?
You have to have a war chest.
Yeah.
So you can cash flow litigation because you know that, and have enough cases that you know that enough of them will win, that you'll have windfalls in the future.
Yeah. I mean, how do you determine, like, whether you think this case is a really good one, this one's going to win? How do you decide which ones to take and which ones to leave?
Well, you have to do a lot of preparation at the beginning. It's not rocket science. In order to succeed on the battlefield, in sport, in other areas of life, it's all about preparation. And you see, that's what lawyers don't like doing, because if you're not being paid, you're spending a lot of time looking into eyeballing a case and the client in order to decide whether or not this is a runner. So you I guess you get a bit of a feel. The client just feels like a true blue. I remember another case against another credit card company, actually, and she was just salt of the earth. You know, she worked as a shop manager. She was just like, this is ridiculous. I'm not going to take this. She was strong. And one of the characteristics you're looking for in a client is that they are prepared to go all the way to trial. Because if they're not, the other side sniff a weakness, and somehow they kind of sense that there's a weakness in the case. So a client who is not rabid, but is, hang on, no, I'm not having this.
Yeah.
that's the sort of client you're looking for, who's got backbone.
Yeah, yeah.
It makes your job running the case through to trial that much more easy.
Yeah, and more satisfying, I imagine, because it goes to trial and you get an actual case. Do you? I mean, how do you feel about settling outside of court?
Well, I mean, it's something like 2.5% of cases that actually go to trial.
Yeah,
it's something very low.
They're really pushing settling outside of court, like alternative dispute resolution, and
they're pushing all of that.
Yeah.
But ultimately, you've got to drag them kicking and screaming, and that's the opponents I end up, in locking horns with, because. There are plenty of opponents out there who will just say, all right, sue me. I don't believe you've got a big enough your equipment is big enough to take it all the way.
Yeah.
And if they're a corporation, big enough bundle. I don't know what the colloquial expression is these days.
And what was I going to say?
Client who's prepared to go all the way, that's what you want.
Yeah. And so in that...
But you see, if they're prepared to go all the way, if you're ready for battle, that's when settlement opportunities arise.
Yeah, yeah.
And so it's the best way of avoiding a trial, is being prepared to go all the way to one.
Yeah, yeah. Being in a strong negotiating position, I guess. So in that particular case with the Bank of America or the credit card case, what was your role in that? You talked about that you prepared all of the case and then you instructed the barrister. Can you speak a bit more about the process?
Yeah, you're a bit like a producer in a movie, and the barrister is the actor. And actually, solicitors are a bit like this. They say, "Oh, I like the look of that actor, that QC. Let's have him." So you actually do marshal a team in some ways, like you're producing a movie. It's not a bad analogy, really. And you might need an expert, like we had a financial expert to explain the impact of the compound interest and what Bank of America was really earning and how much they were really screwing our client.
Yeah.
So you wheel in your expert, you wheel in your barrister. You need a good partnership with the insurer, who needs to know the case is strong and they trust you to deliver, such that they will get the other side to pay their insurance premium, or since the law changed, you had a share of the pie along with the lawyer. So you your job is in some ways supervisory, building a team that you trust, and then the biggest job is often just liaising with the client and actually saying to them, look, I don't believe you. That's nonsense. And actually being quite hardball with them, cross-examining them, treating them mean, so that they know what's at stake, and you flush out all that evidence, all that sort of testimony. You iron out the problems in advance, because once you get towards trial, you're burning money, and you don't really want to be insecure about your client and the strength of your case and the strength of your team. At that relatively late point of proceedings.
And I guess it's good for the client as well, because they're going to be, if they end up having a difficult cross-examination in court, having gone through a process similar, very hard, difficult process beforehand with you, is going to give them good preparation. It's going to stand them in good stead.
Exactly right. It's kind of like that.
Yeah.
And this is why I think that no win, no fee can be a client's best friend, because the lawyer is incentivized to make sure that the case is strong and to properly prepare the case. Traditional law, the taximeter approach, where we just do hours of work and then we send you an invoice and then another invoice and then we say, "Oh, I'm not sure your case is as strong as we thought it was initially." And the client's like, "What?" And they say, "Well, there's this bit of evidence and that bit of evidence, and counsel said this. Oh, and here's our invoice." And it's still the same amount of money. I mean, the legal profession, God bless them, must be the only profession where they get paid even if they deliver a bad result.
Yeah.
Even if they completely lose the battle, they get paid as much as if they'd won it on the traditional taxi meter rate.
Yeah.
I mean, the world needs to wake up.
Yeah. Yeah. Yeah.
So you find that the no-win, no-fee lawyers, they can't afford to lose, frankly. So built into the process is a sort of like reassurance that the case is strong and that your lawyer is motivated to fight for victory.
Yes. Yeah. So you mentioned that Swedish case. Can you explain that a bit more?
Yeah, I mean, I like that case because I think that was a classic sort of vindication of no win, no fee.
Yeah.
Because she was living overseas. She'd been in a relationship with a man in London. They'd bought a property together. He'd made most of the mortgage payments, but she'd helped him to basically buy the house over time. The relationship came to an end. She went back home to Sweden. He stayed in the house. And when she sort of politely raised the topic after the relationship had ended, "What about my share of the property?" he was like, "Go whistle."
Yeah.
And I think she'd ended the relationship pretty much. So
Okay.
he was not in
He
a
was in a bitter
mood.
mood.
And I know the cliche is that women are emotional and men are reasonable, but the reverse was true in this case. What was so interesting was he was really emotional about it and didn't want to give her a penny of the proceeds of the property.
Yeah.
So basically, she was overseas, so she was unfamiliar with the legal system. She couldn't afford to start paying a lawyer on an hourly rate basis. She was a true blue, and she found out about me through an estate agent in the London Bridge area, and I agreed to run no win, no fee case. I agreed to take 25% of whatever she got out of the property, and in return I would work for free. She paid for some of the disbursements along the way, £2,000-3,000 worth. And actually, one of the things I did want to say was, and this touches on the compensation culture point, is that I actually never do completely no win, no fee, because I don't think there's anything such as a free lunch. And I want to know that the clients are prepared to put their money where their mouth is.
Yeah.
And actually writing a cheque and handing it to the lawyer, it's not really about the money. It's that I know that they think deep in their bones that they've got a strong case.
Yeah. It makes it a bit more real and shows commitment.
Yeah, otherwise they're freeloading off the lawyer, like as happened in the personal injury sector. And that's what gave rise to the compensation culture.
Yeah.
Lawyers saying, "Don't worry, I had a client just a couple of weeks ago who said, I'm running a case for him. And he said, I've got this other situation. My wife, she tripped over the pavement outside Tesco's and she actually badly sprained her ankle. And a week later, we saw that Tesco's had repaired the paving. And he was, obviously hunting for a let's go after them. And I was like, look, just go round to Tesco's, speak very politely to whatever department. They're a big supermarket store. They'll have people who get complaints of this nature all the time. Explain the situation. Said you've incurred medical costs because of the sprained ankle.
Yeah.
Invite them to do the right thing.
Yeah.
You might be surprised. And that's what the compensation, that's the way that the compensation culture rode on. And to be fair to the Parliament, when they changed the law in 2013, it was because of those abuses.
Yeah.
Anyway, I
Back
drift
to the
plot.
Swedish case.
So that was a satisfying case. We were as reasonable as we possibly could be with him. But the truth is, that most defendants follow the age-old strategy that the ostriches pioneered, which is sticking their heads as deep into the sand as they possibly can, and ignoring the problem in the hope that it will go away, and that their opponent, pretty blonde Swedish lady, will just go away. And she didn't. And the most we won, and we won reasonably handsomely. This law firm won handsomely because he was a bit of an idiot, really, and he fought it quite a long way before his own barrister was saying to him in court, you need to try and settle this. But by then our bill was, substantial. And so we got a share of the 25% share of the equity, plus they had to pay our legal bill.
Yeah.
So it was a good result for a law firm. It was also really interesting. I did an interview with the Swedish lady. I went and visited her at her home in Sweden. And one of the most surprising things she said was, I felt that, this process stood me on my own 2 feet.
Yeah.
And I felt like I'm an entrepreneur. I know how to take care of my business affairs. And obviously the money was great. But I just feel, she said this, I just feel a stronger character now as a result of that process.
Yeah. Gosh.
So that's special.
Yeah, that is a special case. Because often you hear these horror stories of people saying how, horrific the court process is and it's so difficult. And but having someone who's gone through it and that they feel stronger as a result is quite inspiring. Yeah,
I guess it's those sorts of cases that mean you're stupid enough to jump back into the pond as a lawyer after you've had that experience. That you then forget the nail biting, the months of nail biting, when you were worried you might lose and not get a penny. You see, fear is a very powerful force, and the simple fear of having to lose and the financial damage, even though really your chances of winning are very high, it puts most people off, you see.
Yeah.
And most lawyers off.
Yeah, I bet you could lose a lot of sleep over that. Moving on to talk a little bit about the justice system as a whole. You've had a lot of experience. You've been going for, over 20 years as a litigation lawyer. In your experience, is there anything that you would change?
The problem is we've seesawed, so we've gone from access to justice to what's the opposite of access to justice? No entry.
Yeah.
And the issue fees have now leapt up. Everything is about money. If it moves, bill it. So you now have to pay a massive issue fee in certain cases, in money cases. And it's now can be quite difficult to get that access to justice. Legal aid is rapidly vanishing. Citizens' advice bureaus are closing down. I mean, they talk about legal aid deserts or areas of the country where there's no access to any sort of legal aid and support for those who are poor or those who are on middle incomes. And so it's sad to see it becoming the province of the rich. Yeah. Even just walking here earlier this afternoon, I met a barrister who's a friend, and I told him what I was doing. He said, I said, but I've got a commercial case. I've got a little commercial case, intellectual property case for a business. And it's like, oh my God, the courts system is excellent. Someone answers the phone when you ring up the court. They respond to your emails immediately. And the fees are like twice what they are in the normal county court system. Yeah. And you should get into commercial work, he says. And you think, well, it's just a shame that the court system is so poorly underfunded. And I'm afraid, the Sun readers don't really care about the law. They want to know that the government's shoveling money into the hospitals. Yeah. And
more police on the streets.
But I mean, the police can arrest these people, but who's going to
appear in court for them? Yeah.
Or against them. So, but in my area, the only area I really know about is in the county court system of England and Wales, it's on a bit of a shoestring.
Yeah.
And access delayed is access denied, as they say.
Yeah.
And the problems, the underfunded courts and the bureaucratic complications that you face, make it, very annoying at times, to put it mildly. So I think if I could, if I was Prime Minister, I would make sure that we had a properly funded civil justice system. It's kind of as simple as that. It's not that big a slice of the pie, is it, in terms of the Treasury's overall budget each year?
Yeah, a few of those billions going into the no Brexit deal preparations could go into legal aid, then we could well be better off. Anyway,
shame.
Yeah,
it's a shame because we had a Rolls-Royce justice system, criminal and civil, and I said at the beginning of this interview, I got out of crime, and unfortunately I was in a conference with a client who was arrested for being an accessory to murder, who subsequently acquitted. And we had a conversation with him where we said to him, right, now let's talk about what barrister we're going to get you. And senior partner who was with me in the conference, I'd handled the police station work for this chap, said to him, quite rightly, have you got any money? What about your uncle? I realised that the criminal justice system had changed.
Yeah.
And actually, you needed now to pay for the best representation in the criminal justice system.
Yeah.
So...
there's been a drop in prosecutions, I think, because, possibly because of the legal cuts. And not
I guess it's hitting from both ends.
Yeah.
The legal aid budget is shrunk. The barristers, the criminal barristers and solicitors have seen their pay fall through the floor. But the Sun reader don't really care if a barrister is being underpaid, because they just think all the lawyers in the world are rich. And then you're getting it from the other side, because I guess the Crown Prosecution Service is underfunded too.
Yeah. Well, maybe we could leave it on a positive.
Well, I know. We could try.
Is there anything that you've seen that has pleasantly surprised you? Anything that you feel like, great, this is the reason I'm doing what I'm doing. This is fantastic.
Well, it's better than Poland, where I spent a lot of my year. Their legal system, makes ours look.
There are a lot of Polish listeners.
Well, you might, if you're watching this, you need to know the truth. In Poland, and this impacts on the Poles who are in the UK.
Yeah.
In Poland, they don't think they can trust their civil justice system, and they just don't go there.
Yeah.
But you need to know that actually, in spite of what we've said, it is a very highly evolved and industrious civil justice system. And look, I could go through all my successes. You pick winners, and if a claim has real merit and there's a client who's determined, you find a way. You really do. And so I don't think, and you make it work, and you put up with the headaches and the delays. But a determined client with a strong case will win through.
Yeah. It's a trusted system
if they find the right lawyer.
If you find the right lawyer and you can access the justice system, then it's a good trusted system. Good, very good. So thank you very much, Alex, for talking to me today. It was very interesting.
Well, thank you for letting me gas on in the beautiful late afternoon sunshine. And
for those of you who are listening, do check out Alex's website, redwoodlegal.co.uk. Is that correct?
Yeah.
Yeah. And there you can click on resources. I've been checking it out myself, and there you can find lots of videos and link onto the YouTube channel. So very helpful.
Or if you just put Redwood Legal into YouTube, it will come up.
Yeah.
And we've also got, we haven't really mentioned it, but we've got a support service, because what is happening now is that a lot of people are running their own cases in the courts. So we've got a support service for litigants in person, and you'll find that online and as part of the YouTube channel as well. And I'm writing a book.
Yeah, I remember that you were writing a book. When is it going to be published? Is it based on small claims and working your way through the justice system?
It's to help people who are running their own cases and can't afford a lawyer. And I think I'm going to call it dogfighting in the county court system of England and Wales, because I think the best analogy for litigation is World War I fighter pilots. So that will be the practical wingman for you if you are running your own case. Yeah. And that will be coming out in the autumn.
In the autumn, brilliant. Are you writing it at the moment?
Yeah, I've outlined it. I've done the outline.
Yeah.
And so I should be able to finish it reasonably quickly.
Brilliant, great. Okay, well, when the book is published, I will certainly put a link on it on the Study Legal English website. So, very good. Thank you, Alex, again. And
thank you, Louise.
Thank you for listening. See you next time.
Bye-bye.
Bye.